I said, about water and juice. This officer has an issue.
Good morning.
Okay, I have a trial country at so they can call me. Right, yeah. You said, Judge?
10:15. Yes.
Good morning, Your Honor.
Good morning. How you doing, Ms. Bird?
I'm well, thank you. I believe that's my client on. She just connected.
It is.
Okay.
We're just waiting on the APA to arrive. Just say good morning. Oh, good. I'm sorry. Thank you. Mr. Deagle, good morning, sir.
Good morning, Your Honor. How are you?
Doing well, thank you. Who are you here for? Mitchell, Jasmine Mitchell?
Yes,
Unfortunately, I gotta run to court.
I believe she's in jail.
Yeah, ready on Mitchell.
Case number 2305949 for the state of Michigan versus defendant number 2, Jasmine Mitchell, is charged in count 1, witnesses intimidating, committing crime threatening to kill or injure. Count 3, assault with a dangerous weapon. Count 4 and 5, weapon, stolen firearm.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
Ronald Depot, P63897, on behalf of Jasmine Mitchell.
And are you waiving your client's appearance, Mr. Deagle?
Yes, ma'am. Yes, sir.
For the waive the defendant's presence, what's your pleasure?
Would like to set up for a preliminary exam.
Court will continue to plead not guilty, no statements matter for preliminary examination on November 13th at 10:15.
November 13th. I didn't quite hear the time.
10:15.
10:15. Okay, thank you, Your Honor.
Thank you, sir. Have a good day.
You too.
If I could just inquire, is that the same date and time as the co-defendant?
What date and time do you have for the code?
I'm sorry, I gotta look it up real quick. It's Rynell Nellen. Jasmine Mitchell is the Cody to Rynell. Rynell Nellen has 4 cases. Is that a person? You're right, Judge, I think it's this Wednesday.
I think you're right.
2 days from now?
Sorry?
Yes.
Are you available this Wednesday? Mr. Deagle?
I think so, but I'm not representing his co-defendant or her co-defendant.
We understand that, sir, but we're trying not to hold the same exam twice.
I understand. Okay, well, I'll be there.
All right, so that'll be November 8th at 10 o'clock.
All right. Thank you, Your Honor.
Thank you, sir.
Thank you, Judge. Appreciate that.
No problem. Ms. Burton, good morning.
Again, good morning, Your Honor.
Who do you have?
Ms. Stiles, Tamika Stiles, she's on the Samsung.
Okay. Brilliant stuff.
Case number 23059661001. People of the state of Michigan versus Tamika Stiles. Defendant is charged in count 1, assault with a dangerous weapon. Count 2, malicious destruction of personal property. 200 more than less than 1,000. Count 3, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249.
And yes, good morning, Your Honor. May it please the court, Delphia Burton appearing on behalf of and with Ms. Stiles by Zoom. My P number is 47688.
Ms. Styles, unmute yourself and tell us your name.
Tamika Styles.
What's your pleasure, Ms. Burton?
Yeah, I would like to have this matter scheduled for a preliminary examination.
Court will continue to plead not guilty and set this matter for preliminary examination. Files November 13th at 10:15.
There's just a bad day. I'm in Oakland County and in Plymouth that morning.
How about the afternoon?
Yeah, afternoon's fine.
Okay, November 13th at 1:30.
Okay,
I'll be continued. Thank you.
thank you, Your Honor. Okay, Ms. Styles, I'll call you.
Mr. Fuller,
Yes, Judge.
good morning. Who do you have?
Hey, how
You
are
have
you?
Tom- you have Jeremy Thompson?
Well, yeah, I do, Judge. You know, you gave him until today to get a, to retain counsel. He wasn't able to do it in such a short period, so I believe he's asking just for a court-appointed counsel. He's going to continue looking for counsel, though. He is in negotiations with someone.
Case number 305-96-1101 for the state of Michigan versus Jeremy Tompkins. And is charged in count 1 criminal sexual conduct, 2nd degree, count 2 criminal sexual conduct, 4th degree.
Appearances for the record, please.
Jeremy Tompkins.
No,
Guess I
that's
don't
for the
have an
prosecutor.
APA. Yeah.
Okay, Judge.
Okay, I'm gonna recall it.
All right, I'll have to zoom off and then I'll come back shortly.
All right.
All right, thanks,
Alan.
Judge.
Good morning, Judge.
What can I do for you, sir?
I have Mr. Lehandris Bass. He is on.
Okay. Ready on that.
Case number 2305-96-6001. People of the state of Michigan versus Landis Bass. Defendant is charged in count 1, assault with a dangerous weapon, count 2, weapons of firearm, count 3, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Harold Collins, P56805, on behalf of Mr. Lehandris Bass, who is present on the Zoom screen. Unmute yourself, sir, and state your name for the record.
Landis Bass.
Sir. What's your pleasure, counsel?
Judge, we requested an exam date in this matter.
Court will continue to plead not guilty and set this matter for preliminary examination. Out is November 13th at 10:15.
You're gonna give that 10-15 slot to somebody. Yeah, we'll take it, Judge.
All right.
And I have one other matter, Judge. Mr. Bass has been unable to return to his home. He was prohibited, had restrictions on his tether. He is the owner of that home and the complainant is not there. So we'd ask the court to remove the restriction of him going to his own home address. I believe it's on 2250. Well, I don't want to state his address, the address of record that's attributed to this case, Judge.
I'm gonna let you try to work that out with Ms. Drain and see if you can reach some kind of stipulation.
Oh, okay.
Send over a stipulated.
Will do.
I'll give her a call this morning.
Okay, touch base with me, Ms. Drain. Thank you.
Will do.
Okay.
You're all set. Thank you.
Thank you, Mr. Bass. You can sign off. We're all set.
Ms. Burton, you're back.
Yes, Your Honor. Judge, I do apologize. Ms. Stiles wanted me to inquire if she could have police assistance in going to the home and getting some of her clothes. It's actually her home. And so she has an order to remain no contact with the victim as well as with that location. That she'd like to go and get some of her clothes. She needs about 30 minutes, she said.
Mr. Drain?
Judge, I will call the complainant this morning and see what we can work out, if he can
Ms. Burton, see if we can get with Mr. Drain and you can work something out.
Okay. Ms. Drayton, I'll talk to you. I have a case there this morning, so I'll talk to you then. Thank you, Your Honor.
And Mr. Cohen?
Good morning, Your Honor.
Morning, sir. What can I do for you?
So I've got the matter of Antonio Cowan up this morning, but he is in custody, I believe, at the Division 2 Wayne County Jail.
Are you going to waive his presence or?
Well, I would if I could, except it's our intention to try and waive the preliminary examination this morning if the people are okay with it. So we'll probably need him for that waiver unless they say they won't.
Wait on him then. I'll come back to you.
Okay, thanks.
Ms. George, good morning.
Good morning, Judge. I have Desmond Hogan. He's supposed to be locked up. I'm standing in for Joseph Alex. This is Alex's case. He's out of state right this minute. And all we're asking for is an exam for the 13th in the afternoon.
Call the case, please. Okay. Yes.
Case number 2305-965001, people of the state of Michigan versus Desmond Hogan. Defendant is charged in count 1, assault with intent to do great bodily harm, less than murder or strangulation. Count 2, assault with a dangerous weapon. Count 3, malicious destruction of personal property, 200 or more, but less than 1,000. Count 4, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Judge. Jacqueline George, P 26320, subbing for attorney of record Joseph Alex with permission and consent of Hogan. And Alex talked to him, and there's no problem with me representing him this morning.
You waiving his presence?
Oh, yes, Judge. And we'd ask for the 1:30 on the 13th.
At 1:30, the time is not available. The court will continue to plead not guilty and set this matter for preliminary examination. House November 13th at 12:30.
At what time, Judge?
12:30.
Oh, 12:30. Okay, 12:30 is good. Yeah, because Alex is in person at another court. Okay, 12:30 will work. Thank you.
We continue. Thank you.
Thank you.
Ms. Quick, good morning.
Good morning, Judge. I'm here for Marianne Covington. I believe he is in custody. I would like to wait until he is present.
I'll come back to you.
Thank you.
Ms. Silver, good morning.
Good morning, Judge. How are you?
Good, and yourself?
Good, thanks.
What you have for me?
I have Ferone Thomas with Mr. Fedoruk.
Good morning, Your Honor.
Good morning. You're right on time.
Calling case number 2305-964201, people of the state of Michigan versus Ferone Thomas. Defendant is charged in count 1, homicide, felony murder. Count 2, robbery, murder. Count 3, larceny from the person. counts 4, 5, and 6, weapons, felony, firearms.
Appearances for the record, please.
Good morning again, Your Honor. Mark Fedoruk for the people, P76177.
And good morning, Judge. Gabi Silver appearing on behalf of Ferone Thomas. And he is in the Wayne County Jail. I met with him on Friday. I can waive his presence. We have a discovery issue, as well as we need to set an exam date on this matter.
For the waive the defendant's presence, what's the discovery issue?
Judge, the discovery issue is that I signed a protective order and I received redacted discovery. I asked Mr. Fedoruk to send me unredacted discovery, and he said I would have to take it up with you. So I'm really confused. But I'm asking this court to order that Mr. Fedoruk provide me unredacted discovery today.
Mr. Fedoruk, what's going on?
And just for the record, the people are concerned about some potential harassment, intimidation of witnesses. In particular, we do have a informant in the case that I need to address the court about that later on. But at any rate, so those are the reasons that we're asking that the contact information be withheld, which is what is redacted from the version that was provided to Ms. Silver.
Sign protective orders.
And so, Your Honor, that's position our office takes. I'll defer to Your Honor. Obviously we did submit an agreed protective order, so I'll abide by the court's ruling.
I'm asking the court to.
Purpose of the protective order.
And that's one of the purposes, Your Honor, is to avoid contact information getting out.
Send Ms. Silver the redacted information, please.
Unredacted, you mean,
Will do,
Judge?
Your Honor.
I thought I heard you say redacted. You mean unredacted?
Unredacted.
Thank you, Judge.
All right, as it relates to the exam date, how is...
And Your Honor, one issue I just wanted to take up before the exam date scheduled. Your Honor, so I sent an email to Ms. Reynolds back on, last Thursday. And this relates to our informant. He's also the informant in the co-defendant's cases. So there's basically two other co-defendants at this point. There's Alonta Helton, Ahmad Youssef, and now Ferone Thomas. Now, the Youssef and Helton matters have been conflicted out, and they're now being heard by Judge Jefferson, and they're scheduled for November 16th. Now, just want to make sure court understands. Is
this your Cunningham defendant?
So he was a co-defendant. He has pled guilty. He is going to be testifying against Mr. Helton and Mr. Youssef. Now, what I just want to make sure the court,
As well.
and what I want to make sure the court understands, Your Honor understands, I do not need to call Mr. Cunningham and Mr. Thomas's case. So I'll defer to the court whether Your Honor feels that's a conflict. But again, he's going to be testifying against Mr. Helton and Mr. Youssef. But again, he is a co-defendant technically in Thomas's case. So I'll leave it to the court's discretion.
Well, so long as I don't have to come in contact with Mr. Cunningham, he's not going to be testifying and he's not a defendant in this case, then I'll keep it.
Okay.
Is there any objection to that, Ms. Silver?
I don't know anything about the conflict. I don't know anything about this case, Judge, so.
Well, I know Mr. Cunningham's family, so I recuse myself from the case in which he was the defendant, and then he turned witness, and I recuse myself from that case as well. But I don't know anything about this third defendant and his role and what Mr. Cunningham's role would be.
Okay, I have no issue with that, Judge.
And Your Honor, if you want me to explain further, I can give you the scenario as to how they're connected.
if you feel it's necessary.
Just to make sure. So Yusuf, Helton, and Mr. Thomas were all involved in the planned robbery, which ultimately ended up in the homicide of the victim in this case. Mr. Cunningham set that up. So he is involved in, within the actions of Mr. Thomas and the other two.
But you're not calling as a witness in this case.
I'm not, no, but I just want to make sure the court understands it's all connected in Mr. Cunningham's actions, Mr. Thomas's actions, and the other co-defendants' actions.
All right.
Judge, if the court thinks that it's too messy, I mean, there's already an exam date set in front of another judge. I don't have any issue joining in that exam date. Whatever you wish, Judge.
So, Mr. Fedori, are you using the same? I'm not understanding. Are you using the same witnesses on this other exam as before Judge Jefferson?
I would be, Your Honor. It would just be two officers. For Mr. Thomas's case, it would just be two officers. Those two officers are going to be testifying in Mr.
Judge Jefferson did all three defendants.
And I'm fine with that.
Okay, so we'll send this case to her as well.
Okay. And then just so Miss Silver is clear, it's November 16th at 10 a.m. that exam scheduled.
I may be in trial, but we can broach that when we get there.
Okay, so I'm wondering if I should set this before Judge Jefferson for a probable cause conference so she can join this case with the others.
Yeah, that's just what I was going to ask you, Judge. That's fine. What day would you like us to go there?
Okay, we're calling and finding out now.
Okay.
Check back with you. Give me a second. Miss Evans, good morning.
Good morning, Your Honor.
What can I do for you?
I have a matter here of Mr. Thomas Harris.
Thomas Harris, okay.
Your Honor, and this is Robert Cantor. I was court appointed for Mr. Harris. Has he retained Miss Evans?
Yes, I'll send over a substitution.
Okay, thank you very much.
Thank you, counsel.
Yes.
Okay. So, Mr. Fedori, Ms. Silver, it's going to be an adjourned PCC for tomorrow.
Okay.
7 before Judge Jefferson. Okay?
Thanks, Judge. See you soon.
Have a good
You
day,
said, sorry, Your Honor, you said November 7th at what time?
8:30, I suppose.
Okay, good enough. I appreciate it, Your Honor. Have a good day.
Ms. Evans, you're here on what case is that again? Sorry, Thomas?
Yes, Thomas Harris.
Thomas Harris, okay.
I found my appearance last night.
Okay.
Case number 230-596-6201. People establishment versus Thomas Harris. Defendant is charged in count 1, assault with a dangerous weapon. 2, domestic violence. Second offense notice. Defendant has a second.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Vonda Evans on behalf of Mr. Harris, P number 43475.
Good morning, Ms. Evans. Are you waiving your client's appearance?
He's not here.
Oh, that's
yeah, he's there.
Tell us your name for the record, sir.
Thomas Harris.
What's your pleasure, Ms. Evans?
I'm sorry, sir, Your Honor.
So what's your pleasure?
Oh, Your Honor, at this time, I would just like to indicate very briefly, Mr. Harris was already on bond. There he does epoxy, he does flooring, he was detained, he was going to go to a job, and he was stopped in a truck that he had that he legally rented, according to him, and that he had kept over the time period. And it was just a misunderstanding. He was stopped for that and violated for his tether. We would be respectfully asking this court if he can be released under the same conditions of the case that we're before this honorable court on now, so that he can.
So he's before the court on the tether violation. I thought he was here on the probable cause count.
Yes, sir. Well, Your Honor, he's on both.
Okay, so as it relates to the case itself, are you demanding an exam?
Are we going to hold the exam?
Are you demanding an exam? Yes.
Yes, Your Honor, I am.
The court will continue to plead not guilty and set this matter for preliminary examination. How's November 13th at 10:30?
Whatever you say, Your Honor.
All right, November 13th at 10:30. And I wasn't aware of the tether violation. Ms. Drain?
Your Honor, I wasn't aware of the tether violation either. I don't know what the allegations are. I didn't receive any paperwork.
He was driving a Penske truck and he got stopped with the Penske truck. They contacted the tether. I went to see him last evening and he indicated it's just basically a misunderstanding. And I would just ask that in some way that we can reimpose the conditions of the bond. That I think that they were $50,000 bond with tether, but it was a personal bond, I believe. He was out, actually out.
Came in contact with the complaining witness?
Excuse me, Your Honor?
Are the allegations that he came in contact with the complaining witness or?
No. He, according to him, he was driving a Penske truck that he had rented and he kept it over the rental time because he was locked up in jail. He got stopped, and as a result, when he got stopped, somehow they informed the tether individuals that it was him. And from that's my information from him. No information whatsoever that he had any contact with the complainant.
The tether violation is that he got arrested.
Yes.
Okay. All right.
But it wasn't technically a new. They got the truck back. Everything, you know, he's out here trying to get this money so he can pay his lawyer, and somehow or another, you know what I'm saying, he stops to get some gas. They run out on him. He gets arrested, and then it's a violation of his tether. But there was no contact with the complaining witness at all.
All right. What's your position, Ms. Drain?
Your Honor, it does sound like something totally unrelated to this case that we're here for today. In addition, I have not received any information from the complainant that there has been any contact or any issues with Mr. Harris at all. So I'm not objecting to what counsel is requesting.
All right, the court will reinstate the personal bond with teller. No contact with the complaining witness. You understand, sir? I can't hear you.
Mr. Harris, do you understand that?
Yes, Your Honor.
All right.
All right, thank you, Your Honor. I'll see you on November 13th. Will that be before this honorable court?
Yes, it will.
Okay, last question. Do I have to do anything to reinstate the tether, or what should I do?
We're going to send over an order. I'm not sure how long it's going to take for them to get another tether for him. There's a little bit of a backlog, but it should be within 3 to 4 days. At the latest, I'm thinking.
All right, very good. Thank you, Your Honor.
Thank you.
Good seeing you both. Thank you, counsel. Bye-bye.
Miss Evans, do you have the discovery?
I do not.
Okay, I will send that to you today.
Okay, Barry, do you have my email? If not, I can find you.
I looked it up.
Thank
you
so much. Okay, bye-bye.
Bye.
What can I do for you guys? Why are you here? What's up?
Good morning, Wes Compton. I have a matter up with my client, Mr. Harmon, this morning, set for exam at 9. It's a waiver. It will be a waiver.
Okay. What's your name again?
Wes Compton.
Last name?
Compton.
Compton. What's the defendant's name?
William Harmon.
Okay.
And Judge, I will be standing in for this case.
You're gonna stand in? Okay.
Whenever the court is ready.
Case number 2305771-301, people of the state of Michigan versus William Arnold. Defendant is charged in count 1, child abuse 33, count 2, domestic violence.
Appearances for the record, please.
Good morning, Judge Westcott. Appearing on behalf of Mr. Harmon, present to my left, P number 7513.
And good morning, Your Honor. Shelley Drain for the people, P number 60249.
Your name for the record, sir.
William Harmon.
There's a date and time set for preliminary examination, counsel.
Yes, Judge, I had an opportunity to explain to my client first probable cause that the government has to prove reasonable fault, as a preponderance standard, probable cause standard that crime was committed, and more likely than not, my client committed it. He's been made aware of that. This time it's our intention to waive the preliminary exam and seek arraignment and serve court.
Mr. Harmon, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You understand you have a statutory right to have a preliminary examination by waiving the same. That means you won't have it when you will be bound over to Wayne County Third Circuit Court as you stand charged in point four. You understand that?
Yes, Your Honor, I do.
You understand the nature and the purpose of the preliminary examination?
Yes, Your Honor, I do.
You understand if you were to have one, the prosecution would have to establish that the crime charged with was committed in the city of Detroit that was probably caused by the committed.
Yes.
Is anyone forcing you to waive your right?
No, Your Honor.
Is anyone promised you anything?
No, Your Honor.
Are you waiving your right freely, voluntarily?
Yes, Your Honor.
Any objection from the people?
No objection to the waiver, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court Criminal Division for proceedings. His arraignment on the information date and time will be November 20th, 2023 at 9 o'clock a.m.
Thank you, Judge. Have a good day. You understand.
Thank you, sir.
Thank you, Judge.
Place a call to the jail for Colin, C-O-W-I-N.
So the victims have been here for that case they got. Want me to see the information. Like, oh, let's see. I need them. Okay, I'm gonna be on there. I apologize. But you were to ask the victim the waiver. They're here at the prosecution.
We'll be calling on it in a few minutes.
Okay, thanks.
Harmon, they say, well, what we just did, yeah, the victim is here. We don't have the information on the prosecution. We're not there. The next day, never get a chance.
Can I help you?
That's the witness.
There it is. She come on here. Two.
No. All right, I only have one device today, three batteries, that's why I just came on over.
Okay.
So I'm in the building, I'll just come back.
Did you already give her the name?
No, she didn't do. Oh, she didn't. The prosecutor and stuff. Oh. We be on, this.
Good morning, Mr. Taylor.
Good morning, Judge. How are you?
Good. What can I do for you?
I am here for Jeremy Tompkins for a schedule for a pre-probable cause conference.
Oh, are you retained?
I am.
Okay.
I just submitted an appearance. So I did it electronically, so I don't know how soon it hits your system.
The only issue I'm having is we don't have an APA here for Tompkins yet.
Okay.
Ms. Strain?
Yes, Judge, I'm here.
So would you happen to know who the APA is for Jeremy Tompkins?
It's Elizabeth Moore, and I thought she was on here because I texted her. Yeah, I'm sorry, Jeremy Tompkins. Yes, she is on this case.
Okay.
She was
And
on
she
here,
was here earlier today, but she left.
Yeah. Okay, I will tell her to get back on Zoom.
Okay, thank you.
Or
So, Mr.
maybe I
Taylor,
can stand in.
Yes,
I
John.
see a good friend of ours is running for mayor. Did you see that?
I did. I did.
I didn't know about it. He's kept his campaign kind of quiet.
Yeah, he's been out there a little bit. I've had some communication from him.
I wish him well.
Always, always. How have you been, Judge?
I'm doing good. How about yourself?
I got no complaints.
Got 3 jailers. That's what 10:45. Lewis 11:30. Jackson.
Oh, Jackson.
Oh. Okay, Ms. Morris here.
Sorry, Judge.
Good morning.
Good morning.
Mr. Taylor.
I'm here, Your Honor.
Okay, we're ready.
Case number 2305961101 for the state of Michigan versus Jeremy Thompson. Defendant is charged in count 1, criminal sexual conduct, second degree. Count 2, criminal sexual conduct, fourth degree.
Parents for the record, please.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
And good morning, Your Honor. If it may please this honorable court, Richard Taylor, P number 55237, on behalf of Mr. Jeremy Tompkins. Mr. Tompkins, can you unmute yourself and state your name for the record, please?
Jeremy Tompkins.
What's your pleasure, Mr. Taylor?
Your Honor, I was just retained last evening in this matter. I have received some discovery from the, which is quite voluminous. And given the nature of this matter, I'm respectfully asking the court so that I can have some conversations not only with Mr. Tompkins, with the APA in terms of how they want to proceed in this matter, if we can have a second PCC in this matter to determine whether or not we need to proceed to exam, unless the court wants to do otherwise. He's prepared to waive the 21-day rule in this case.
Is there a possibility this may resolve itself short of an exam?
I don't believe so. So I would just, if the court pleasures just to set it for an exam, then I think that's what probably would be the proper course.
All right. That being said, the court will continue to plead not guilty and set this matter for preliminary examination. House November 13th at 12 o'clock.
The court say November 13th?
Yes, sir.
Your Honor, I have a administrative law hearing on that date. And again, I would respectfully ask if we can extend it out just a little bit. As I indicated, the discovery in this matter is quite voluminous. There are some protective orders that I need to look at as well.
A little bit will extend it to November 15th.
And unfortunately, Judge, I'm not available on the 15th. I started trial on that day.
What time is your administrative hearing, Mr. Taylor?
It's at 9 o'clock.
You won't be done by 12?
I should be done by 12. The only issue, and I apologize to the court for my schedule, is that immediately thereafter that I have a violation of probation hearing in 40th District Court.
That doesn't take very long.
It shouldn't, but
to run into all kinds of issues once we go beyond 13th, because we're not having to do this more being the trial than whatever else you have on your schedule.
For what it's worth, Judge, I am hoping my trial will be done by the following Monday. If the court is even willing to push it out to the 20th. Understood.
See, if I don't do it that week, Mr. Taylor, then I'm looking at after Thanksgiving, which I'm not willing to go about. Not that.
Judge, as I indicated, I'll leave it to the court. We're prepared to waive the 21-day rule. So I will leave it to the court's discretion at that point.
November 13th at 12:15.
Thank you.
All right, thank you. Why don't we continue?
Judge, I just would like to know that there are kids talks in this case, so now that I know defense counsel is, I'll be sending that over to sign. Thank you.
All right. Hey, have a good day, Mr. Taylor.
All right, thank you, Your Honor.
Yes. I'm sorry? Yes. Ms. Drain?
Yes, Judge.
Are you ready on Gadsden?
Yes, Judge. Yeah.
Oh, yeah.
Case number 2305952101. For submission versus Richard Jackson. Defendant discharged in count 1, home invasion, first degree, count 2, carjacking, count 3, robbery, unarmed, count 4, assault with intent to do great bodily harm, less than murder by strangulation, count 5, domestic violence. Defendant has a habitual offender, second offense notice.
Yes, for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Nicole Jones on behalf of Mr. Gadsden. My P number is 58961.
Tell me your name for the record, sir. Sure. Today's the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is not present, and I cannot proceed without her testimony today.
Judge, we would ask this case and dismiss.
So, or court will dismiss this matter without prejudice.
Judge, Mr. Gadsden is also on tether.
The dismissal will be taken care of.
Thank you. Judge, he also posted a bond. Does the court give out the bond refund slips or anything like that?
I don't.
Okay. All right.
Judge already has.
You said he has it. Oh, okay. Then I'll just step the cause away.
Yeah, Mr. Richard Taylor retained it.
Oh, he did.
Yeah. Okay, you're all set. Thank you. Appreciate you.
Judge, I ran over Marcus Kenneth at the homecoming last weekend, big boy. 6'11".
My son, gang, you know, he went to UMass. So
Okay.
he was at homecoming.
Oh, nice.
I was looking across the guy was drinking. Looking around. 6'11". Boy still worth 60 million. Like the NBA, 13 years. He retired so young, he only 49.
Okay. What's your name, sir?
Antonio Cowell.
Okay. Thank you. Ready, Mr. Cohen?
Yes,
Yes.
Judge.
Okay, we're ready on count.
Case number 230595770 for the state of Michigan versus Antonio Powell. Defendant is charged in count 1, assault with a dangerous weapon, domestic violence, sexual assault. Defendant has a felony conviction for advisory and a habitual offender third offense notice.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249, standing in for the Assistant Prosecuting Attorney, Erica Moses.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151. I'm appearing by Zoom with Mr. Antonio Cowan, who also appears by Zoom from the county jail. Mr. Cowan, can you please state your full name?
Antonio DeVito Cowell.
What's your pleasure, counsel?
Your Honor, at this time, it is, Mr. Cowan, please stop me if you've changed your mind for some reason, but at this time, the defense is requesting to waive the preliminary examination and have this matter bound over to circuit court.
All right, Mr. Cowan, please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with the complaint. You understand that? You understand that, sir?
Yes. Yes.
You understand the nature and the purpose of a preliminary examination?
Yes.
You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit, that there's probable cause to believe you committed?
Yes.
Is anyone forcing you to waive your right?
No.
Has anyone promised you anything?
No.
Are you waiving your right freely? Sarah?
Yes.
Any objection from the people?
No objection to the waiver, Your Honor.
Court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court, the criminal division for further proceedings. His arraignment on the information date and time will be November 13th, 2023 at 9:00 a.m. Bond will be continued.
Thank you, Your Honor. Nothing further from defense.
Thank you, Judge.
All right, thank
I'll see you soon, Mr. Cowan.
Okay, thank you.
You're all set, sir. Thank you.
All right. I'm done. Yeah.
Your Honor, is Division 2 also going to put Mr. Covington in front of the camera?
That doesn't look like the same division. Wayne County Jail.
Okay, I left that way. No. Okay.
What's your, sir? Oh, that's okay. You have Covington for me?
There was one other guy, I believe his name was Covington.
Yes.
Okay, he'll be sitting in the chair. I'll just stay logged in if that's okay.
All right, thank you. I appreciate that.
Thanks.
In the meantime, while we're waiting, let's see what's going on with Jackson. Yes.
Calling case number 2305-58301, people of the state of Michigan versus Joseph Jackson. Defendant is charged in count 1, assault with intent to do great bodily harm less than murder by strangulation. Count 2, domestic violence.
For the record, please.
Good morning, Judge. Robert Kenneth, here on behalf of Mr. Jackson, stands to the left.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
There's a date time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is not present in court, and I cannot proceed without her testimony today.
So ordered. The court will dismiss this matter without prejudice.
Thank you.
Thank you.
Thank you, Judge.
Yes, sir. Thank you.
Are you Mr. Covington?
How you doing?
Are you Mr. Covington, sir?
Yes.
Okay, I'm ready. I think I need an APA here.
I'm here, Judge.
Okay. I'm ready.
Yeah. 0595-3901, people of the state of Michigan versus Marion Covington. Defendant is charged in count 1, homicide, felony murder. Count 2, robbery, count 4, weapons, felony, firearm.
Appearances for the record, please.
Good morning, and may it please this honorable court, APA Jonathan Hitz, appearing on behalf of the people, P85288.
Good morning, Your Honor. Neighborhood Defender Service by Cheryl Quick, P83973 on behalf of Marion Covington. Mr. Covington appears from Division 2 of the Wayne County Jail.
Mr. Covington, tell us your name for the record.
Marion Covington.
What's your pleasure, Ms. Quick?
Your Honor, we would like to, I believe at this point, we'd like to set this for an exam. I have not seen any of the discovery yet. I believe that APA Hitz has just a protective order to the court, and so I suspect discovery to be forthcoming.
Yes, I did send a proposed protective order into the court, Judge. I'm hoping we can get that back today, and I'll make sure to get discovery out today. I'm returning from vacation, but I've taken a look at the file, and I should be able to get everything else today. Okay,
I'll make sure that gets signed today. And we can set this matter for preliminary examination. How was November 7th?
You say November 7th, tomorrow?
Oh, I'm sorry, I'm on the wrong day. November 14th.
Judge, I'm starting trial on Monday, the 13th, a CSC 1 trial. I expect to be tied up with that probably till Wednesday, the 15th. I'm in trial the rest of this week and then the beginning of the week of the 13th. So
I'm open in the afternoon, November 16th, that works for the court in the square.
I didn't hear you, Mr. Hicks.
I just know you do Tuesdays and Thursdays, so I was going to propose the 16th. I'm open on that day if that works for Ms.
Are you available on the 16th?
yes, I'll make that work.
Okay, November 16th at 10 o'clock.
I'm sorry. I do have a motion here except for 8:30 a.m. I think it'll be done by 10. It'd be nice if we could do a little bit later in the day if that's possible.
Your Honor, I would need the afternoon as well, please.
November 16th at 1:30.
That's perfect. Thank you so much, Judge.
Thank you, Your Honor. Your Honor, may I have a breakout room with Mr. Covington before we log off?
Okay.
Thank you.
And I'll hang on just in case there's anything else that needs to be addressed on the record.
Actually, Your Honor, before the breakout, I do believe we would like to request a DSU report on Mr. Covington.
First degree murder premeditated?
Yes, Judge.
It's felony murder, but I would object to a modification.
I'll refer to pretrial services.
That's all we're asking, Judge. Thank you. That I believe that's all we're going to be addressing on the record.
Breakout room.
Thank you.
Oh. So right after that.
And that got checked. One.
Hey, man, how we doing?
Move that. Yeah.
Yeah.
Huh?
See, you got a sweat on.
No, I don't. I wouldn't never touch that. There, actually. Had it on 90.
Who had it on?
I don't know, touch
I got it trying to sabotage this now.
Nice.
Arneka, you did that? Arneka, you did that?
I didn't even notice that right.
I didn't either. You was like, who touched that?
Never even saw that.
You was like, who touched this? I said, I didn't know it was there. I said, if I knew, I would have touched it.
Just so big.
Sir, what's your name and date of birth, sir? Okay. Not here, not here yet.
Should we do something with this?
Okay, thank you. I know. Yeah.
Attorney Mercer call.
Mr. Houston. You get a okay. No client?
Judge, you're not gonna believe it. I guess we can put it on the record. You heard worse, I'm sure. This is ridiculous.
Calling case 2359519, State of Michigan versus Gerald Wilson. Defendant is charged in count 1 assault with named count 2 felony firearm, count 3 carrying concealed weapon, count 4 domestic violence. Here's the verdict.
Good morning, Your Honor. Shelley Tree for the people, P number 60249.
And good morning, Your Honor. May it please the Honorable Court and your staff. Norman Houston, P number 36280. Appearing on behalf of Mr. Gerald Wilson. Your Honor, this matter is set for preliminary exam today. The court may recall I had numerous conversations with my client prior to the probable cause conference, because this is the case where permission was requested to allow my client to visit the hospital, Beaumont Hospital, as the court may recall, and I went through all kinds of communication before the court and also with sister counsel in efforts to affect that. Prepared the order, it was served. I sent a copy to my client, and then this morning he called me at 7:30. Normally I don't take calls in the morning. I just happened to be coming out to court for another matter. And when I spoke with him, he asked what time was the hearing today. And I told him 10:15, knowing that it was actually 10:30. It is now 10:37. And I had no idea what my client is. I tried calling him, I got his voicemail, I texted him, I have not received a response. So I don't know what's going on.
What? That seems a bit unusual. For us to consider the people that about some good cause as to why he's not going to issue case for this letter to appear both opposite concentration.
It was 10,000 cash, it was reduced, and he's untethered.
I'm sure there's some explanation, I'm just wondering what it is.
I don't either. I can't help it. I have to wait to hear from him. That's all I can say.
Thank you, sir.
Thank you.
I bet you Ms. Burton has her client. I bet you Ms. Burton has her client.
He's in custody. He would be here if it wasn't. His parents are here. So. Yeah.
Mr. Mercy.
Not sure.
Like trying to sabotage us, y'all. Trying to broil us on high. 90 degrees.
Have a P number yet?
No, not to the end of the month. Sadly.
Why so long?
Well, I'm not sure why that's what it was scheduled for. But I just learned about the Michigan Law Basics course. What about that? In February, the Supreme Court ruled that every bar applicant has to take a Michigan Law Basics course. It's like 12 hours before you can be sworn in. So I did this weekend, so it shouldn't hold nothing. Yeah.
So what does that entail?
It's the 6 main practice areas. It's like a written and video debrief for what you should know about each of the 6 subjects. So they got to answer questions correctly. I could use some other words, but we can take more interesting.
You guys ready in Westbrook?
He's on the way up.
Have a little bit of mercy.
Sir?
Eight, 9, 4, 4, 3, 2.
Right. So Westbrook. You all right? Yes. Wait a minute. Be on hold for me. Step around there.
Calling case 2359516, Real Estate Mission versus Blake, Devon Westwood. Defendant is charged in count 1, home invasion, first degree. Count 2, criminal sexual conduct, assault, intent to commit sexual penetration. Count 3, assault, intent to be great bodily harm, misdemeanor, murder by strangulation. Count 4, domestic violence.
Good morning, Your Honor. May it please this court, Gabrielle Pruitt, requesting permission for practice under court rule 8.120 under the supervision of APA Shelley Green.
Commissioner Grant.
Yes, good morning, Your Honor. May it please the court, Delphia Burton hearing on behalf of Mr. Westbrook, my plea number is 47688.
Yes, how you doing? My name is Blake Westbrook. Yes, daytime separate preliminary examination. Are we ready to proceed?
Correct.
Your Honor, the complaining witness in this case is Ms. Kiara Murphy. I have spoken to her and I'm expecting her to be here today, so I will ask you to speak to her. Thank you.
Mercy said before.
And I was waiting for that.
People have reached out to the plaintiff this morning.
No, no, Your Honor. I haven't reached out to the complaining witness. I can give a call right now.
Yes. Up to the time. You know my eyes have been used. Yeah.
Hello.
Okay, I think we waited long enough.
Your Honor, the complaining witness is not present. I did speak to her on the phone. She said that she doesn't have a ride here. She didn't
So what
say
was she just gonna do, just sit home?
that is my impression, Judge.
Did she didn't reach out to you, did she?
No,
This happens.
Or try to still like it.
We are back on the record on case 2359516 people versus Blake Juan Washington. People, here's your witness.
Your Honor, the complaining witness still hasn't appeared. I was able to speak to her over the telephone and she told me that she's not present because she didn't have a right to get here. I'm not sure why she didn't communicate that.
Yeah, because I'm left wondering what's her plan. She's just gonna sit there and things are gonna happen magically or what? She made whatever contact the court or contact the prosecutor to let you know. You said you were in communication yesterday? On Friday?
Yeah, we spoke last week, Your Honor, and she told us that she was gonna be here, And then the next day, someone from our office from the victim's advocacy called, and they weren't able to contact her. They would have made that transport happen.
So it's not like she had a number of issues, but a number of circumstances. All that being said, it's really.
Yes, sir.
What about the cause to bring my will dismiss without prejudice? I need dismissal.
Wrapping up. You guys. Okay, same thing. Okay. Take care.
Take care.
Don't come jump with you right here. But don't be coming. Oh, 25 days. Taking out hands. And this is dismissed. I've made it. You can write a book in this building. He said he didn't know what happened. He said, can't stop something. Oh, goodness gracious.
No.
Mercy is racer and to keep her cops and the two maps that help writing.
I think that's gonna be a dismissal anyway.
You guys see Ms. Barnwell? Okay.
No, Your Honor, Ms. Barnwell did not take the court mercy. Shall we?
Mercy. My apologies, Your Honor. The delay, we are, I had a client that had underlying mental issues.
What they got to do is showing up for hours.
I was had a complete that matter with Your Honor. I do apologize.
Calling case 2359498, people of the state of Michigan versus Devon Lee Bennett. Defendant discharged in count one assault with name collective, count two aggravated domestic violence.
Yeah, good morning, Your Honor. Shall we read the people, P number 60249?
Thank you. Good morning, Your Honor. Treat Daniel Mercy at P72620, representing Mr. Bennett. For the record.
Devon Lee Bennett. This matter was scheduled at 10:15. Time is now 11:39. Mr. Mercier, why are you so late?
Your Honor, I had a matter over at Third Circuit Court, and I had the court call your staff. I wanted to know that I was on the right.
That was after I called you.
That was me trying to get out of it, saying I have to leave, I can't finish this case.
I called you probably a half hour or 45 minutes later than the exam was scheduled. I should never have to call you.
I do apologize, and I explained on the phone the error I had in office.
Is the date time set for exam or ready to see?
No, I am not able to proceed with this crime. Completing witnesses not present. And I can see without her testimony.
I didn't make a motion to dismiss, Your Honor.
So order the court will dismiss tonight without prejudice.
Okay.
Somebody took the first. Thank you, sir.
Commissioner Brooks, Your Honor.
Yes, sir.
Just wanted to clarify. Prosecutor Moses. I do appreciate the patience. I try not to ask too much patience.
That's all, bro. All right.
All right. Good morning, you ready, young Ms. Lewis?
Yes, Jeff. Good morning.
Calling case 2359502 for state of Michigan versus Lehman Lewis. Defendant is charged in count 1 assault, to be rape out of the arm, arrest, and murder by strangulation. Count 2 domestic violence, second offense notice. Domestic violence and or knowingly assaulting a pregnant woman, second offense notice. Defendant has an additional fourth offense notice. Here's for the record.
Good morning, Your Honor. I'm at this court, Gabrielle Pruitt, requesting permission to practice under Court Rule 8.120 under the supervision of APA Program.
Commissioner Grant.
Good morning, Your Honor. Wendy Burnwell, B42505, on behalf of Mr. Lewis.
Tell me your name, sir. Lamar Lewis. There's a date and time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor.
How many people?
One. The people call Priscilla Johnson.
Ma'am, please step forward, give your name and the spelling of your name to the young lady seated there.
She's looking at it. We have to be right.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat in the witness box right next to me. Keep the voice up nice and loud and speak to that microphone. To your left. If I have no problem hearing you, I may have to ask you to remove your mask, okay?
Okay.
Maybe you're right.
Good morning. Can you just pull a little closer to the microphone? Okay, you can lift the microphone up and put it in your lap also.
Hello?
Yeah. Thank you. Can you take your first and last name for the record?
Priscilla Johnson.
Ms. Johnson, how do you know Lehman Lewis?
That's my boyfriend.
How long were you dating for?
I know, but it's now a year and a half.
And if you recognize him today, if you see him today, would you recognize him?
Yes.
Do you see him in the courtroom?
Yes.
Can you please point to him and tell the court I don't know what he's wearing?
He got on green.
Let the record reflect that identification of the defendant.
So no.
Ms. Johnson, where were you on October 20th of 2023?
I was in the hospital.
You said, while you were in the hospital, did you have a medical procedure?
Yes.
After your medical procedure, who came to visit you?
Lehman Lewis.
And what happened when the defendant came to visit you?
He walked in the room. I was on the phone with the shelter. And I was hanging up. He thought I was on the phone with me and he just started beating me. He jumped on top of me and just beating me.
When you say
he showed me beating.
When you say he was beating you, what was he doing with his body to your body?
He jumped on the bed, his knees was, my procedure was in my chest and my stomach. He jumped on top of me with his knees. He started choking me with both his hands.
While he was choking you, how was your breathing?
I couldn't breathe. My eyeballs started rolling in the back of my head.
Was he saying anything during this time?
You want me to say the exact words?
If you would, for
Bitch, I'm gonna kill you. There's something I gotta do.
you just testified that Mr. Lewis choked you. Did anything else happen while you were both in the bed?
I was already under a whole bunch of covers because I was cold. So I was right up in the covers when I was on the phone with the shelter. When he entered the room, what made me look at the door was because the doctors and the nurses and them don't come in and close the door. That's when I looked over and I seen him. When he ran, he just came full force, jumped on top of me. He was choking me. I had my phone in my hand. I let the phone go. I started trying to do like this. And I took one of his fingers and started saying, help, help. That's when the doctor and all that was running the room. He was punching me in my face and beating me all in my head. Punching me. Beating.
Ms. Johnson, you testified that you tried to call for help. At that point, did someone come into the room?
Yes.
Who came into the room? Do you remember who came into the
The
room?
doctors, nurses.
What did you do when the medical staff entered the room?
I took off.
Okay. And when you took off, where did you go?
I ran out the door and I was running. I wasn't thinking to cover up. I was just running out of all blood was pushing out, blood was everywhere. On the floor, the wall. And
When did you stop running?
when they started pointing and said, come this way, and they hit me in the room.
Who hit you?
The doctors hit me in the room, the nurses.
I just have one more question for you.
Mm.
You said you were at the hospital.
Mm.
What hospital were you at?
St. Grady.
And what city is that in?
Detroit, Michigan.
In the county of Wayne?
Yes.
No more questions for the witness.
Cross examine.
Good afternoon.
Good afternoon.
Were you under the influence of any drugs while you were there in the hospital?
I was on a lot of medications. I had just had an open procedure. I was in the hospital.
Okay.
I was on a lot of medications.
Okay. What kind of procedure you said you had?
They had to stick in scopes and stuff down my throat to my stomach to see what was the other health problems that was causing problems that caused me to go to the hospital.
Okay, was there a nurse there? You said people came in the room,
Yes,
but you ran out of the room?
I ran.
Okay,
Once he was able to get off of me,
all right,
I just ran.
nothing further.
Any regret?
No, Your Honor, thank you.
Is there anything else to say?
What was your condition at the time that you were in the hospital?
My condition, I have a lot of health problems. I have a whole lot. I'm stay sick.
Were you pregnant at the time?
No.
These questions based on my questions.
No, Your Honor, thank you.
Thank you, ma'am. You may stay. Any other witnesses for the people?
No, Your Honor, thank you.
Witnesses for the defendant? People.
Your Honor, the people moved to bind over as charged in the jury.
Right, with respect to the second offense notice for with respect to assaulting a pregnant individual. That acts of that can be stricken.
It's not really a count. It looks more like
A notice. Okay. I believe it's a question of fact.
I agree. It's a question. In fact, what after hearing the testimony of Senator Johnson, satisfied that the people have met their burden of probable cause as it relates to the charges contained in the complaint warrant. Stand up, sir. Court finds those charges were committed in the city of Detroit. The court finds probable cause to believe this complaint committed. And to be found local to Wayne County Third Circuit for criminal division proceedings. Is a ranking on the information date and time will be November 13, 2023 at 9:00 a.m.
Right, I'm wondering what his bond is at the moment. Oh, actually,
I meant to ask if we could address bond.
Okay.
The complaining witness told me prior to taking the stand that last night she started receiving phone calls from the defendant in custody making threats about whether or not she was gonna show up here to take the stand.
and I think that that's something that could be verified. So we would need verification for that because he's in custody in the Wayne County jail. And I'm not sure what kind of a communication she has.
Your Honor.
Okay.
While the deputy is going to hear her, I will say that she told me he was calling her from other inmate numbers.
Okay, Ms. Johnson, let me remind you that you're still under oath, okay? It's been brought to the court's attention that you say you've been contacted by the defendant, is that right?
Yes,
When was that?
last night.
What time last night?
Let me look at my phone. The 1-800 is 1-866-516-0115. That was at 125 Saturday. The one for yesterday, I think my daughter had
Oh, she do that?
I was playing on the phone. She on the team.
1-866, what's the name?
1-866-516-0115.
And you talked to the defendant? Is that yes?
Yes.
What did he say?
You just threatening nothing up.
Tell me exactly what he said.
Lying ass bitch. I ain't do nothing to you. Bitch, I'll fucking kill you. I ain't do nothing to you. You don't remember. That's your plan. You didn't do nothing to me. And for me not to show up in court. His bond is $1,000. He gonna be on the teller. He He wanna come wherever I'm at, or he gotta go to a halfway house. And the court date is supposed to be tomorrow. And then y'all called and told me that I had to be here today, the court was today at 8:30.
Okay. And you say
He
you have,
called a couple times today.
and you say you have that log in
The number?
the shelter.
He called my daughter number too. Her phone broke. She's the only one that's able to answer. I got voice messages on there, but she can't read my messages. It said inmate call.
Oh, the voicemail says.
Like, I don't answer.
Can you play that for me too? Put it up to the mic.
My daughter is trying to get some voice. My daughter, like, here it goes. Pick on one of them. It's the same, it's trying to change contact.
They tank the acquisition. Detroit Detention Center.
It's totally for me to put some money from the tank. It's way more than this.
Okay, I got you. Thank you very much.
Ron,
Ms. Barbara,
I couldn't hear what she was.
she was saying that she received text messages asking her to put money on the account for the Detroit Detention Center inmate to contact you.
Yeah, but it was just a general thing about the
Who
inmate.
else is in jail?
But what do you mean, who else is in jail? She
Who else
could
is
have a
in jail?
brother in jail.
If it wasn't
Excuse
fit,
me?
we'd all be drunk.
There was a what, Judge? No, be quiet.
Sir, quiet down.
Stop, sir. Judge, we cannot just assume. Assuming is not a part of it. You can't just assume he's the one calling from a detention center.
I'm not assuming anything. She told me it was him.
So she said it was in because there was a text message or something?
No, she said she talked to him. And he
Oh,
made threats to her.
okay, and did you just say the detention center last night?
No, that was on October 30th.
Okay. And she has like some,
You want to show Ms. Brown what you had?
This is one. Now you can see all the time. 125, 1236, 1114. Incoming. 15 minutes, 3 minutes, 0 minutes, 1 second. That's it.
Judge, I see a 186. I see a 1866.
This is where you calling me from.
I'm not calling, and that's that's that number that Wayne County Jail uses, that tail, whatever it's called, tailgate or something like that. I call it while we on the record. Anything else? Thank you, ma'am. You may say. So what are you proposing tonight?
Judge, can you tell us what the bond is?
75,000 cash. Sure.
Judge, we just wanted to know for the record that the defendant keeps contacting the complaining witness and she is here.
Barbara?
All right, Judge, I would encourage my client not to do such a thing if he has done such a thing, because it's totally traceable in spite of who's in the movie.
One thing I've learned from your client is that he's awfully bold and brazen. The allegations I've heard here are true. He attacked a woman in the hospital while in the hospital bed. And then he calls her the day before her court date and threatens her, makes numerous calls before then. Court is going to suspend all calls coming from Wayne County Jail. Sorry. Sir, when I say no contact, that's exactly what I mean. You're not doing anything to making things bad for yourself, sir. Because all that is going to come out. It's not painting you in a very favorable light. You're making things very difficult for your attorney who's trying to defend you. And I suspect was going to ask this court to address your bond. But that's out the window now. I wouldn't dare touch your bond because I think you're a danger to the community. So thank you, sir. I'll continue if I don't raise it.
Thank you.
You can give us a court date, Judge, sorry.
Yes. November 13th at 9 o'clock.
Is it too late to ask for forensic?
Too late to ask me.
Okay. Okay.
John, 1:30 now?
Yes, we're down to 1:30.
Huh? Yeah, but he ain't about that license. Only on Wednesday. Only Wednesday.
Watch that. Bye-bye. I mean, obviously. Bye, everyone. Have a good day.
Thank you too.
I put my stuff over here.
Better move it out the way, because we have to do something.
I did. No, I just thought I couldn't remember. No, if I feel like something going on.
want to move everything in all options.
Okay, because I'm like, what, oh, yes. Oh, my God. I'm thinking, look. Right. Oh, sorry. Okay, thank you.
Thank you too.
She's afraid. Who? Yeah, he gone. She said she thought he was gonna attack her. She thought he was gonna attack her. That's why she was sitting in front of the whole thing. So I moved all that stuff and started bringing all that stuff up here. And 5A. Jason, I kept speaking. Yeah, I couldn't get a little. She like, I put my stuff in here. No, I won't. He gone. Listen.
Here, sir.
We love their wedding on Saturday. We had a wedding downtown here on Saturday and a friend of ours left her phone. I don't know.
Must have been really exciting.
They must have been, yeah, so. Right, I guess this is. Yeah. Her license is in the packet, so.
Is this still nice out or is it starting to?
Doesn't look like, yeah, it's supposed to rain, but it's starting to.
How you doing today, Mr. Montgomery?
I had a good kids. Mine's had a 5 week, so it really wasn't football. So it's kind of quiet, not really nothing. Got back in the gym finally. I hope so.
So good.
It's interesting. I still haven't heard back from the department of the potential internship situation. Never got a call.
Be patient.
Just out of curiosity, how long have you been in it?
Sorry?
I said, out of curiosity, how long have you been in it?
1:30.
1:30.
Yes. Hello. Hey, there you go. How you doing? All right, how about yourself?
So all I see outside, wants to know what happened with the things. Okay. Last time, Judge, we ran out of ink, so I just need to make a copy. Have a good day, Judge.
All right, you too. Hey, how you doing? What? Boylston, last name Boylston, they said they supposed to go to a witness group. Could be, I don't know, I just have one case that's on beyond board. It's not set to 1:30. Okay.
Yes, sitting here the whole day, whole time? You didn't get out of your seat? Right, yeah, sure.
I was supposed to be close to 60.
Yeah, it was, it doesn't feel like it. That's not.
Yes, Ms. Bickerstaff, what can I do for you?
Good afternoon, Judge. I have an exam before you on Wednesday, and I was wondering if I could send the court a witness detainer for that case.
Okay.
Where would be the best place to email it to?
Send it directly to me, Kenneth.King at 36thdistrictcourt.org.
Okay, I'll send that now. Thank you.
No, we don't have a doctor. Okay.
Yes, great. Was everyone thinking maybe the date got mixed up with Friday?
What's that? Yeah, essentially Thursday and Friday.
I know.
Yeah. And I don't teach on Thursday.
You know? Bonus.
So I was about to call, they send out the doctor, so I took the advice, doctor, I didn't see my name. I took the bill. I looked at my schedule.
Yeah. Not even PCC, so we don't schedule.
I didn't PCC.
Maybe practice Wednesday crazy.
How do you do 9:15, 9:30?
Okay. And Thursdays are homicide day, that's a little surprising.
Couldn't get any takers on homicide prosecutor said he didn't try. They said some other kind of time. So Russia did recently, we just had one.
Oh, really?
I mean, we had 3 exams, but the latest one said,
Oh, wow. Okay. yes. And it's like,
Make sure. People leave it open all the time.
maybe get those calls, people talking about that, yeah, I'm just that. I
Yes.
tell them, I said, I'm pretty good, like,
Oh, they won't call you back.
Yeah, I was gonna say that, they won't call you again.
I always like to get the calls, like, I tell them.
Right.
They be like, for real?
If there was any.
Oh, so.
Right.
Oh, cool, so it's,
Right, exactly.
oh, Veterans Day, so you. So.
Yeah.
Cause I would have definitely showed up looking, so. I'm like, where's everyone?
Yeah.
It's interesting though, those phone calls. That was a.
He did, I really did.
He seems a little cooler.
It seems like we got just like, he turned me down in 5 minutes. Like it went from 110 to 105.
Right.
Yeah. So, we'll have parties here on more.
Rosie's out there.
Those kids about witness.
They got a witness in the room.
So witnesses.
Well, it's on 90, you say 75 now.
Mr. Wilson, how goes it? Mr. Wilson, how goes it?
Hey, Judge, how are you?
How goes it?
It was well. It goes well. It votes well.
Hi, Judge.
Hey, how are you?
Good. I'm sorry, I didn't mean to keep you waiting.
No problem. Just 1:30, that's what time it starts.
Yeah, sure.
It's the ring. Council President Breon.
Yes, that's right.
Ready?
Yes, Judge. Yes.
Calling case 2356339, people of the state of Michigan versus Breon Deshaun Moore. Defendant is charged in count 1 aggravated indecent exposure. Sexually delinquent person knows indecent exposure. Defendant has a dismissal before the police.
Good afternoon, Your Honor. Elizabeth Moore on behalf of the people of P84724.
Good afternoon, Eric Rosie, on behalf of Mr. Moore.
There's the date time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor, the people are prepared to proceed. I would like to address just a couple of preliminary matters, of course. First of all, I do ask for a mutual sequestration order with an exception for my officer in charge who is not here, but I am expecting him to be here. His name is Detective Cecil Stevens, CECIL, last name STEPHENS. I would also like to note that the complaining witness's mother and grandfather are both here. They would like to be present for the examination. I do not anticipate the legal witnesses.
Yeah, as long as they weren't present at the incident, and I have no objection to the presence.
All right, the officer in charge.
No objection.
Ladies and gentlemen out there in YouTube land, Right, witness or potential witness, involved at this time. It doesn't appear to be any other witnesses in the courtroom. It's showing in the back. I'm not sure who you are. That's the mic. That being said, anything else?
Yes, Your Honor. The complainant witness in this case is, I believe, 16 years old. I would just like to confirm that she will not be visible in any way by the camera.
Take care of that right now.
Thank you, Judge. And additionally, I have had extensive communication with the victim and her mother. They are asking if the court would be willing to mute the victim's testimony given her age. If the court is not inclined to do that, I would just ask if the court would be willing to mute it up to the point where she says and spells her full name. If the court would mind.
I can do that.
I would think that her testimony should be. I believe that her testimony should be heard. I mean, I understand her age, but this court has had many complaints on various types of cases, sexual in nature or assaultive in nature.
I just want to view her name.
That's
her name.
That's.
Thank you, Judge. Those are all the preliminary matters that I have at this time.
All right, let's call you.
Thank you, Judge. People call Nadia Boylston, Nadia Boylston.
I didn't think you were going to call her name.
I'm sorry, Judge. I thought that we were muted already. Are we on or off? I don't know.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat with the box next to me. Keep your voice up nice and loud. Speak to the microphone to your left. Maybe you're ready.
Thank you, Judge. Ms. Boylston, I would like to draw your attention back to April 6th of 2023. Do you remember that particular day?
Yes.
Now, specifically focusing in around 4:00 p.m. in the afternoon. Do you remember where you were at that time?
Yes, I was on the queue.
When you say the queue line, do you know what city you were in?
Detroit.
So is that in the Wayne County?
Yes.
Now, you said that you were on the queue line. Were you with anyone that you knew on the queue line?
Yes.
Who were you with?
My two cousins.
How old are your two cousins?
16 and 8.
Now, back in April, do you know how old they were?
15 and 8.
So is it fair to say that they're both minors and you were the oldest person?
Yes.
Now, while you were on the queue line, where exactly on the queue line were you located?
I was towards the front.
Were you facing forward or backward?
I was facing forward.
Were you standing or seated?
I was standing.
And you indicated you were standing. Were your two cousins standing or seated?
They were standing.
Where were they in relation to where you were?
Judge, I have to object this to what's the relevance of what the cousins were in your position.
Sure, I asked for a little bit of leeway. I think this is demonstrating who she was there with, and we're about to get to what she was able to see. And so I think who was around her at that time is relevant. Thank you, Judge. Now, where in relation to you were your two cousins?
My 8-year-old cousin was standing in front of me, and then my 6-year-old cousin was standing close to her diagonal.
And you said that you were standing. Were you holding on to anything in particular?
I was holding on to the pole.
Now, while you were on the queue line, did something draw your attention?
Yes.
What drew your attention?
There was a man in the corner, and he was just staring at me.
I'm going to ask you to keep your voice up next time, okay? You said that there was a man in the corner. Which corner are we talking about?
He was in the left corner.
So, was this closer to the driver or farther away from the driver than where you were?
It was closer to the driver.
You said that he was in the corner. Was there anyone in between you and this man?
No.
Were there people around where you and this man were?
Yes.
Would you say that the queue line was empty, full, or somewhere in between?
It was packed.
But you, just a moment ago, I want to confirm, said that there was no one in between you and this man.
Yes.
Was this man standing or seated?
He was seated.
Would you recognize this man you saw him today?
Yes.
Do you in fact see them in court today?
Yes.
Please identify where they are seated and pick out article of clothing there.
He is seated to my right and he's wearing a black hoodie.
Let the record reflect that he's identified the defendant.
So noted.
Now, what initially drew your attention about this man?
He just kept staring at me and he wouldn't look away.
Do you know approximately how long he was staring at you?
No.
Now, when you noticed that he was staring at you, did you notice anything else about this person?
Yes.
What did you notice?
He was also masturbating or looking at me.
So I want to back up for a second. You said that he was masturbating. How do you know that he was masturbating?
I saw it.
When you say it, is there a particular part of his body that you're talking about?
Yes.
What part of his body is that?
His penis.
Did you see it outside of his clothing?
Yes.
And when you say that he was masturbating, was he doing anything with his penis?
Yes.
What was he doing?
He was just rubbing his penis up and down in like upward down kind of motion.
Was he doing that with his hand or something else?
His hand.
Was it one hand or both hands?
It was one hand.
And you indicated that he was still looking at you while this was occurring?
Yes.
After you saw that, what was going through your body at that time?
It was a lot of anxiety and I started panicking.
What's the very next thing that you did?
I looked away and I started to panic and cry.
After you saw that, did you do anything?
I asked the guy next to me to switch.
When you say you asked the guy next to you, where was this guy in relation to you and the man?
It was behind me. The guy who actually switched, he was behind me.
Did you, without saying specifically what you said, did you tell him what you saw?
Yes.
Did he agree to switch?
Yes.
So did you switch places with him?
Yes.
So after you switched places with the guy next to you, were you closer to or farther away from the defendant?
I was farther away from the defendant.
Could you still see the defendant?
Yes.
Do you know if he was still masturbating at that time?
I don't know.
Now, did you see anything happen next related to the defendant?
I'm sorry, I don't understand.
I'm gonna ask a different question. What's the very next thing that happened?
After I asked the man next to me to switch, we switched places and then he kind of confronted the guy.
So I want to be very clear. The guy that you switched places with confronted the defendant. Is that what you're saying?
Yes.
And when you say confronted, what do you mean by that?
He kind of stormed up to him and basically told him.
Objection, hearsay.
Thank you, Judge. So you said that he stormed up to him. Did he have words with the defendant?
Yes.
Did the defendant say anything in response?
No.
After that interaction occurred, did you see anyone else interact with the defendant?
Yes.
Who was that other individual?
The bus driver.
And did you see the bus driver have words with the defendant?
Yes.
Did the defendant stay in the same seat or did he move to a different location?
He moved to a different location.
Do you know where the defendant moved to?
He got off the bus.
Did you watch him get off the bus?
Yes.
Is that the last time that you saw the defendant?
No.
When was the next time that you saw the defendant?
A couple seconds later, when we got back on the bus.
Did you use the same door to get off and then re-enter?
No.
How did he re-enter the bus?
The door he re-entered was like slightly behind the door he entered.
And did you see him re-enter the bus?
Yes.
What did you do when you saw him re-enter the bus?
I started pointing him out, telling the bus driver that he got back on.
After you alerted the bus driver that the defendant was back on the bus, what happened next?
The defendant tried to get back off the bus. And the bus driver's like holding his arm out, trying to stop him before the police could get there.
Did the police arrive?
Yes.
Do you know approximately how long it took for the police to arrive?
Not exactly, it was fairly quick.
Was it within a couple of minutes?
Yes.
Did you see the police interact with the defendant at all?
Yes.
What did you see with your eyes?
The defendant kind of snuck under the bus driver's arm and then exited the bus or train. And the police put him against like the bus stop wall and just patted him down and kind of restrained him.
Did you see the police place handcuffs on him?
Yes.
Now, after all of this occurred, did you have a conversation with any police officers as it relates to this?
Yes.
Did you provide a statement?
Yes.
While that was occurring, did a police officer present you with a photo of a potential individual?
Yes.
Would you recognize that photo in that piece of paper you saw today?
Yes.
During closing counsel, people's proposed exhibit 1. Commissioner Approach, Judge?
Yes.
Ms. Williamson, I just handed you a one-page document. Do you recognize that?
Yes.
How do you recognize that?
This was the guy who was masturbating on the train.
I'm actually going back for a second. Is that the piece of paper that a police officer presented you with?
Yes.
How do you recognize that?
I don't understand.
Does it have your handwriting on it?
Yes.
Does that appear to be a fair and accurate copy of the piece of paper that you were presented with at that time?
Yes.
Does it appear to have been tampered or altered?
No.
This time people moved to admit people supposed to have 1.
No objection. Admitted.
Now, on that piece of paper, is there a picture of an individual?
Yes.
Do you recognize that individual?
Yes.
What do you recognize that individual from?
From the train. He was masturbating.
Does that appear to be the same individual that you identified in court today?
Yes.
And did you indicate that in your writing on that piece of paper?
Yes.
And did you sign that piece of paper as well?
Yes.
1 second, Judge. There are no further questions at this time. May I approach the witness and publish the exhibit?
Yes. Cross-examine. Sure.
I'm gonna probably need to use that at some point, so. Good afternoon, ma'am.
Good afternoon.
So this happened on, I think this was opening day of the Tigers, is that right?
Yes.
So it was packed downtown, right?
Yes.
It was cold, in fact, I think it was even snowing that day.
I don't remember.
Okay, fair enough. Fair enough. But it was really busy on that train. Would you agree with me?
Yes.
Okay. And so much so that one could say that other than the people that were sitting down, everybody else was crammed up against each other to stand on the train. Would that be fair?
Kind of, yes.
And there was a lot of people that were taller than you that were on the train. Would you agree?
Yes.
Okay. And what was the distance between you and the person you saw that was masturbating?
Like a couple of feet from each other.
All right. So could you point to something in the room? It's like, pretend like you're standing where you were that day. Okay. How far away was the person you saw doing masturbating? Anyway, I'm going to approach you. Pretend like I'm the person that you saw doing it. So just tell me to stop when I get to the distance from where you saw it. Ready?
Stop.
Oh. And for the record, would you agree with me that it's approximately 10 feet? 8 to 10 feet?
fully security status.
And so on this crowded train, that 8 to 10 feet distance, there was nobody between the two. Is that your testimony?
Yes, there was nobody blocking my view.
And do you know approximately how many other people were on the train?
No.
Now, this happened when you were with your cousin and your two cousins from out of state, correct?
Yes.
And you said your younger cousin was behind you?
He was in front of me.
Front of you, okay. And the next eldest cousin was diagonal from you.
Yes.
When you say diagonal, if I'm you, would that be diagonal to the left or to the right?
To the left.
To the left. And the person you identified as the client, was he to the left or to the right?
To the left.
To the left also. Okay, so your cousin is to the left. The person who is doing this is also to the left, correct?
Yes.
And now when you were alerted the guy behind you, you were upset, obviously.
Yes.
How long did you observe this act taking place before you turned and got someone's attention?
A couple of minutes.
When you say a couple of minutes, do you mean literally like 60 seconds, 120 seconds?
Yes.
Really? Did you say anything to anybody while this was going on?
No, when I realized what was happening, I texted my cousin, the cousin that was there diagonal.
Was your mom on the train as well?
No.
Oh, you're just letting her know, oh my gosh, there's some freaky things going on.
Yes.
Gotcha. And then you got upset naturally, and you told the guy behind you to switch places.
Yes.
Where was your younger male cousin? Did he switch places also?
Yes.
What about your cousin that was diagonal from?
No.
She stayed with you.
She stayed.
She stayed there. And then you saw the person get off the train, and then try to get back on the train, and then the police showed up.
Yes.
Now, when the police showed up, you said you saw the police taking the person into custody, more or less.
Yes.
Right? Specifically, you saw the police put him up against the wall, patted him down, and handcuffed him.
Yes.
How far away were you from the person you met?
Pretty close.
Were you still on the train when that was happening?
No, I got off the train. The bus driver, he said that the police wanted witnesses.
So, Judge, can I watch? Yes. Now, could you tell for the record, how many pictures are on that?
Just one.
How many pictures did you see before you saw that one?
One.
So the only picture the police ever showed you to identify a person was just that picture?
Yes.
They didn't have you look at a bunch of different pictures and say, can you pick out of the 7 or 8 different people who did this?
No.
Did they have you identify somebody on the scene?
No.
Did the police say, is this the guy who's handcuffed up against the wall, the person that was playing with himself?
I'm sorry, I don't understand.
I'm sorry, did the police, when the police arrived, did they talk to you?
Yes.
Did the police officers ask you to point to the guy that did this thing?
I don't know.
So this happened, you identified the person, the only photo of a person you were shown, is that true?
Yes.
You identified this person at 6:07 in the afternoon, correct?
I don't know the time.
What does it have a time on there?
Yes.
Okay, is that at 6:07?
Yes.
Okay, and this alleged happened around 4 o'clock in the afternoon, correct?
I'm sorry, could you?
The whole incident started at around 4 o'clock in the afternoon, correct?
I don't know.
Okay. I think the prosecution asked you this specifically on April 6, 2023 at 4 p.m. Were you in the city of Detroit County in the state of Michigan on the Q line? You answered yes. So You agree that at roughly 4 o'clock in the afternoon is when this whole incident started?
Yes.
Okay. So roughly 2 hours after this happened, they show you one picture. Would that be the way that things happened with you?
Yes.
Okay. Now, how long did the entire train ride last before from the point when you got on the train to the point when the police arrived? How long would you say? I understand, that's right. That's right. The police, they didn't ask you to give them a description of the person.
No.
They didn't ask you to sit down with a sketch out of the street.
No.
Okay. They didn't have you look at a bunch of mug shots.
No.
Nothing. Or look at some video.
No.
Forgive me for asking this question, and I mean no disrespect. When the person that you saw that was incarcerated, do you know if they were flaccid or they were not? Do you know what I mean?
Yes.
If you can.
They were right.
And if you recall, how long was that person doing that act? What I mean by that after the act.
I don't know exactly how long.
And this person never said it. True.
No.
Another question.
Can you read it?
No, you are.
So let me try to get a fair understanding. When you saw him doing this, you asked to change places. You said the person that you asked to change places with confronted the defendant. Is that right?
Yes.
And then is that when the defendant moved to get off the train?
No, he kind of sat there for a minute. He didn't get off until the bus driver came out and asked him to.
Do you recall what he was wearing on that day?
No.
What is it specifically that you recall about other than exposing himself?
He had the same shaped cut like in that picture.
And was there a period of time when you lost sight of him? Did you ever lose sight of him?
I'm sorry, I don't understand.
Was there ever a point in time when you didn't see him? You left your presence?
When he got off the bus,
Yeah, that's how long before you saw him again?
like a couple seconds, as he re-entered.
So he was only gone for a couple of seconds.
Yes.
Did you try to get back there?
Yes.
And did you tell anybody what happened?
No.
You didn't tell the bus driver?
Oh, yes, I told the bus driver.
Tell anyone else?
No.
Any questions based on the questions?
Fair.
No. Thank you. Thank you. You may stay.
You just get that back.
Any other witnesses for the people?
Yes, sir. People do intend to call one additional witness.
Point offer.
Your Honor, people were going to call Detective Cecil Stevens, who did an interrogation.
I see. For that purpose, Judge, we will stipulate to use so long to that it was knowing intelligent for exam purposes.
Okay.
So we're gonna-
Judge, can I just one moment?
Sure.
Your Honor, at this time, people call Detective Cecil Stevens.
All right. Please give your name and spell it to the court reporter, sir.
Detective Cecil Stevens.
Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. Please have a seat. Maybe, you're ready.
Thank you, Judge. Good afternoon, Detective. Please restate your name for the record.
Detective Cecil Stevens.
Are you currently employed?
Yes, I am.
Where are you employed?
The Detroit Police Department Sex Crime Unit.
Now, you said that you are in the sex crimes unit. What is your current rank in the Detroit Police Department?
Detective.
How long have you been a detective?
Since 2017.
And how long have you been in the Detroit Police Department in general?
Going on 20 years.
Do you know when you were assigned to the sex crimes unit?
Yes, it was in February of 2020.
Now, I'm going to draw your attention back to April 6th or 7th of 2023. Were you assigned to the officer in charge of a particular case?
Yes.
Do you recall the suspect's name?
I hope I'm saying correctly, but it's Mr. Young.
Now, as officer in charge, did you conduct any sort of interrogation with that suspect?
Yes, I did.
Did you do so after the suspect was in custody or prior to anyone being in custody?
After he had been placed in custody.
So would you recognize the individual that you interrogated and saw today?
Yes, I do.
Do you in fact recognize anyone in the courtroom today as that individual, Mr. Brown?
Yes, I do.
Please identify where they're seated, pick up our court clothing wearing.
He is the gentleman seated with the black coat on with the hood.
Let the record reflect when you identify the defendant.
So,
Now, Detective Stevens, did the defendant agree to speak with you on April 7th, 2023?
Yes, he did.
Is there a certain protocol that you follow as the detective in interrogating an individual?
Yes, I for one make sure that he reads or I read his Miranda rights and that he fully understands them. If he understands and he's willing, I usually have him initial next to each right, claiming that he understands.
Is there a specific form or document that you use for this?
Yes.
Did you use that document in this case?
Yes, I did.
Would you recognize a copy of that form if you saw it today?
I would.
Showing people's proposal exhibit 2, I recognize there's a stipulation, it's still cash to approach.
okay.
Detective Stevens, what have I just handed you?
The constitutional rights certificate of notification.
Is that the form that you filled out with Mr. Moore on April 7th, 2020?
Yes, it is.
And does it appear to be a fair and accurate copy of the form that you filled out?
Yes, it does.
Has it been tampered or altered in any way?
No.
People move to admit who's supposed to admit 2 into evidence.
No objection, for exam only, Judge.
Admit.
And Detective Stevens, did the defendant complete that form?
Yes, it did.
Is every single right on there initialed by the defendant?
Yes, it is.
Did the defendant also sign that document?
He did.
After completing that form, did the defendant agree to speak with the court?
Yes.
Your Honor, pursuant to the stipulation, I will not be tendering to defense court. Now, in addition to that document, the conversation you then had with the defendant, did you reduce that to writing in any way?
Yes, I did.
Did you recognize a copy of that writing you saw today?
Yes.
Joint opposing counsel is supposed to be free. Commissioner approach?
Yes.
Detective Stevens, what have I just handed you?
Form for the statements of the defendant.
Is that a 2-page document?
Yes, it is.
Is that a document that you drafted during your interrogation with the defendant?
It is.
Does that appear to be a fair and accurate copy of that document?
Yes, it does.
Does it appear to have been tampered or altered in any way?
No.
People move to admit people supposed to do it for evidence.
No objection, for exam only, Judge.
Admit it.
And detective, on that document, is there a series of questions and answers?
Yes, there is.
Did you personally write that out in your own handwriting?
I did.
So when it says, Q with a colon, is that a question that you asked the defendant?
Yes, it is.
And then if it says A with a colon, is that an answer that you received from the defendant?
Yes.
Now, do you paraphrase that answer, or is that answer directly from the defendant in his own words?
Usually I write in his own words. Occasionally I will have a paraphrase and make sure that he reads what I wrote.
Now, specifically, go about a third of the way down on that first page. Can you please read the first question? Out loud, please.
I'm sorry. Which you said.
The first question on the statement.
Gotcha. Can you tell me what happened yesterday?
And can you please read the first sentence of the defendant's answer?
The defendant said that I was on the queue line talking to white girls. I exposed myself and playing myself. I didn't realize what I was doing. I was trying to talk to the white girls, and this guy that was standing up told queue line that I was jacking off. The driver stopped and I got off. I got caught by the police when I got off.
And Detective Stevens, I'm going to draw your attention to page number 2. Please read the first question and answer on that page.
The question was, did you masturbate on the queue line? The answer was no. I was just playing with myself. I was trying to force it on you.
There are no further questions for this witness. May I publish exhibits 2 and 3?
Yes. Cross-examine, Mr. Wilson?
Sure. There's more to this statement that was left out, edited out by the prosecution. Would you agree with me? There's 3 other questions.
Those questions weren't asked, of course.
She didn't read that into the record. You didn't read that into the record, did you?
Which questions did you refer to?
The next 3 questions. Read that whole page after the first question and answer. What else does it say?
The second question is, did you expose yourself? His answer was, I already had my hands in the pants when I approached them. The next question is, did you pull your penis, out of your pants? His answer was yes. The third question is, did anyone see pull your penis out of your pants? His answer was not that I know of.
This was, I'm sorry, the time on there was what time?
The time was 4:03 p.m.
What time did it start?
3:48 p.m.
What time did you begin the interrogation?
Oh.
Showing you what there's the constitutional rights certification notification. Is that time on there, sir?
3:27 p.m.
So roughly 30-some minutes of conversation. Those 5-6 questions were asked during that whole time.
Usually, after the constitutional rights, I do record the interrogation record, taking down a description of the defendant, and asking him a few questions about his background, such as parents, et cetera, et cetera.
Isn't there more of a back and forth between the 2 of you that wasn't written down on just those 2 questions?
More than likely, yes. Just to gauge his intelligence level. Should I take a statement from this person? Usually trying to find out if he's capable of giving a clear and accurate statement.
Have you ever had any interactions with my client prior to this?
No, I haven't.
Did you do a background check on him prior to interrogating to see if there was any mental health issues?
It was back in April. I cannot recall what I did prior to speaking.
Is that kind of standard policy or protocol that before you interrogate somebody, find out if this person is mentally distressed?
Not a protocol.
Is it something that you do in your practice?
Normally, yes.
So you don't know specifically what determined whether or not, or found out rather, whether or not this was a person with mental health issues.
I can't recall if I found that out prior or if I didn't find out anything prior.
Cases of this kind, specifically this type of behavior, in your experience as an officer, tends to be from individuals that have mental health issues, crisis, schizophrenic, etc. Do you agree with me?
It depends. Sometimes, yes, sometimes, it's more 50-50 thing.
Now, you were the officer in charge, were you the officer that presented the photograph to the complaining witness for identification purposes?
I don't believe so, but I have to view the photo to sure.
Thank you. Showing you what's smart as people's exhibit number 1. Is that the same? Is that a photograph that you have presented to the complainants on this case?
No.
Now, the Detroit Police Department's policies to comply with the Constitution, it's their function, I mean, not your function, excuse me, is to show an individual a series of photos for a lineup. Would you agree?
Depending on the situation.
So for identification purposes, a series of photos for a lineup or a live lineup is preferred. Would you agree that is the department's policy?
Preferably, yes.
A single photo is not appropriate under almost all circumstances. Would you also?
No. I've had several investigations where a single photo was proper.
Really? Was that upheld?
I'm sorry?
Was that conviction, did that result in a conviction?
Yes.
Was it upheld?
Yes.
It was. Okay. And was that also a case of this type?
I've had cases of this type where I used a single photo.
And nobody objected to it?
No.
Nobody challenged it?
No.
Okay, thank you. I would just take back. No further questions.
No additional follow-up.
Thank you, sir. You may step in.
People have no additional witnesses.
No witnesses for the defense, Judge. Thank you.
Your Honor, I do believe that there is more than enough evidence to bind over in this case. We did hear from the defendant in the case who indicated that she was on the queue line, that there were other individuals around, including 2 people that she knows to be under the age of 18. She said that she noticed an individual, she identified that person as the defendant staring at her, then she saw him masturbating. She clearly indicated that she saw his penis and that she saw his hands rubbing his penis up and down. That is certainly sufficient for an aggravated intimacy exposure. Additionally, we heard statements from the detective that the defendant indicated that he was on the queue line, that he was, that his penis was exposed, as in out of his pants. And then furthermore, I understand that want to make sure I'm putting this correctly. I understand that the defendant's initial response to being asked, "Did you masturbate on the queue line?" that it was no, but then he followed it up with saying, "I was just playing with myself," which ultimately is more than sufficient for a record of an aggravated exposure, where it just has to be some sort of touching or fondling of genitals. I also believe that the identification is pretty clear in this case. The victim says that she saw the defendant, she saw him exit the queue line, re-enter the queue line. She saw that same individual being handcuffed by the police. Then within 2 hours, she saw a picture of the individual that indicated it was him, and also today in court, dated in court identification. The record is more than clear, and I reserve it for the right to provide.
Judge, with respect to the identification, I think that's clearly where my issue is. I understand you made a statement, notwithstanding. However, but if I could, Judge, just to make it record. There. I don't think that there's ever any circumstances in which a single photo is anything but suggestive. And you say, what did this person do to me? And it's just one picture, a series of pictures. I can see an on-the-scene identification is sometimes allowed, but even then it's on very limited circumstances. So to say that this single picture shown to the complaining witness after she's observed somebody being arrested, whom she lost sight of, maybe for a few seconds, but notwithstanding, still lost sight of the person, is unduly suggestive, especially in light of the fact of the trauma that she obviously the comment. Plus, the in-court identification, my client is the only individual sitting next to me. It's not like it's an array of people. So an in-court identification is problematic. I understand, of course, he made a statement, which we will follow up down the way, etc. Not saying that, Judge, we think that the identification here should be suppressed at this juncture, which has been tainted for an improper lineup.
So even if I were to adopt your argument about the one photo, even throwing that photo out, you still have in-court identification to deal with, in addition to the defendant himself saying that he is in fact the person who we're all talking about.
I understand, Judge, and like I said, there are motions for the comment.
That doesn't have anything to do with me or my purpose.
Right. Yeah, well, okay, then I should put it like this, that this court is well aware that we have referred to the criminal competency of the state. Your Honor has had an opportunity to review the report. Your Honor has taken notice that while we have stipulated to its content, that within the body of that report, it indicates that I'm this officer has indicated, I'm sorry, as the court is well aware that the report had indicated that he suffers from several mental health disorders, one of which is schizophrenia. If this officer was being truthful and being all candid, he would have seen that this gentleman had been committed based on a link. Had he done his job, had he actually seen what what my client had been like, trying to say, his mental health situation was of a state of mind where he was not necessarily understanding fully and completely all of his rights at that time. Therefore, I don't believe that his statement should actually come in based on that without having done a full background check on my client.
Where in the law does it require police officers to do a full background mental health check?
It's actually the burden is on the people to show preponderance of the evidence.
And they have done that with the rights form that, mind you, you stipulated to.
I stipulated to.
The voluntariness of the state. Correct. Just because he's schizophrenic or he's had mental health issues does not mean, in the past, does not mean that he's suffering from some kind of mental health ailment that might prevent him or from giving a voluntary statement, knowingly intelligent giving a voluntary statement.
Actually,
all that being said, the court is satisfied that their burden of probable cause as it relates to the charges contained in the complaint form. The court finds those charges were committed in the city of Detroit. The court finds probable cause for discipline committed. Found over to Wayne County Third Circuit Court Criminal Division for proceedings. This arraignment on the information date and time will be November 20th, 2023 at 9:00 a.m. Are there any issues as to time?
Judge, we asked about the continued. There have been no concerns that have been raised either by myself or by the people to this court.
That is correct, Judge.
We continue.
Thank you, Judge.
People have your exhibit.
Thank you, Judge. Judge, I'm so sorry. Order for counseling and testing for disease infection. May I submit that to the court?
Yes. Yes. That concludes the docket for today, folks. Hope to see you tomorrow, same bat station, same bat time. All right.